okay. Right. No, okay. Anyway, sounds like I'm not going, so that'd be all right. It's all right.
Save yourself the trip to Sydney unless you want to do it.
Well, no. Well, I'm not going to do it for the sake of doing it. It's just, I just thought she was short. Someone pulled out. Anyway, I made myself available.
There's been a couple of new mentors coming, like Tom McDonald's throwing his hat in again, which is good. But he's only 10 minutes away, which is good. So.
Yeah.
So, yeah.
That's convenient. I've got you, Guy.
Yeah. Is it? I don't know.
It might not be convenient.
Then you can go. This is a dog's breakfast. You let me help you every week now, or
I had one last time who was battling. Like, he was absolutely battling. And I got his plan in front of me, and I asked him to talk me through 6. And it was in the inner west in Sydney, and he was going back to million plans. That's as deep as he went. And it was just a dog's breakfast. And anyway, he got his plan check done. I think Steph, you saw this one too, didn't you? But it ended up being that the next guy didn't show up, so we put him through another 45 minutes because he was sitting around waiting for the next to do his rural or something anyway.
Yeah, right.
And he got through in the end, which was great because he rang me afterwards and he's like, if he didn't get that reality check, he wouldn't have got through. So
yeah.
It can be the case, right? Like my mentoring surveyor, inverted commas, he's in his 70s. Not that's got anything to do with it, but he's got so relaxed because he's been registered for so long that his advice I kind of take with a grain of salt, and I go to the younger guys and they're like, oh no, you got to do this, 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 this.
Well, yeah, like this guy was really good. He just obviously had a terrible mentor. Steph, we're just talking about that fella that did the plan check workshop last time that you sat in on, and there was like he did the first session and the next guy didn't show up, and we put him through a second one. You were there for that, weren't you?
So I remember a guy where he had the wall widths all over the shop and stuff. I may have missed it. I may have moved on. That was a busy day for me.
Yeah. Anyway, he ended up. He said to me at the end, "Do you think I can get through?" And I said, "Mate, you're going to struggle." And anyway, he eventually must have put the hard work in and did quite well apparently. So that's good. But
I feel like there is a bit of a MasterChef effect in the exams of if you kind of don't know what you're doing. I feel like they kind of, oh, you've given us enough. Okay, you've got it, kind of thing. I don't know. Just hearing a few stories of people who probably kind of scraped through, and a few stories of people who should have nailed it and didn't. But
yeah, I feel like a lot of it's the examiners looking how confident you are with it as well. And if they smell blood, then
maybe that's
fine. Yeah. Not that any of you guys will be bleeding. I hope.
Got my
I still don't know where the country is. So.
Yeah. What are you doing, Marty? You there, Marty?
Yeah. No, I was just going to leave it all up to you. I was just going to join in and record it. So
where were we up to last week?
Well, basically, what did we do, guys?
Finish searching.
You
finished searching. That sounds ominous.
Well, I'm still coming to the searching workshop.
So you're all experts now. Great.
Well,
I think we were trying to figure out how to search for a large flat, I think.
Yeah, a large flat. That's JB's homework.
Well, it won't be for 2 weeks then, because he's in Perth.
Yeah.
I think if there's something that you'll get excused for not knowing, that'll be up there.
Yeah, yeah. Well, this was more for our own purposes, really. But at any rate, I think what would be good to follow on, and it would suit both rural and urban, is titling and titling issues. I don't know whether you've got any samples there. I can try and find some samples while you get started.
Just see what I've got. So we can start going through some titles. Anybody got a particularly interesting title that they want to go through? I'm using as an example. Otherwise, I'm going to dig something out anyway.
I have not my subject lot, but the railway line I've got going through it is a limited title.
Yep.
But like it does have a planner survey. I don't know if that would be something that they actually care. Like I vaguely know why it's limited, but will they delve in any further in the exam? Because it's not actually my lot.
Probably not.
Cool. All right. Sorry about that one.
I do have an example of what you call, Guy, a Franken title.
Oh, great.
You want me to share that?
It can depend on who your examiner is too, because if you get Joby, I think he's got a stack of titles that he throws on the desk and throws a few questions at you with regards to. So it'd be really good to actually have a look at the titles and try and identify some of those things that you could get asked. Also, land grants. You guys doing your rural, just make sure you got your land grant. So if you're having trouble obtaining that, then yeah, we could probably have a look at it tonight. But
I'm currently, I've got a titles folder, and every time I buy a title, it ends up in there. And I've just created an interesting folder within that folder. So I'm just going to go through them, and it'll be good for next time.
Yeah, sounds like a plan, mate.
Yeah. So you got that title there, Jeremy?
Oh, yeah, hang on. I'll just share. Get that up. You see that one?
Hold on.
You see it?
Yep.
Oh, yeah.
Okay, what's interesting about it?
We've got all these easements and reservations, easements, restrictions, just a ton of them. 3 pages worth.
Yeah.
If it's not interesting enough, then someone can find them all.
33 notations. Well, why don't you just lay that on the screen and we'll start going through them.
Yep. Okay.
So this is a title search. I'm hoping that everybody's seen one of these before. Just remember that when you're doing a survey of a block, you're surveying the title. So you need to be looking at your title because it's going to tell you what's going on with that block of land and also what it actually comprises too. So don't always just get hung up on looking at the plan. You need to be, your title is your first point of call. So your folio will be usually your lot and DP, lot/DP number, but you can also have an auto console number in there. We'll have a look at one of them in a minute. And then you'll have your bits about that addition of the title and when you actually did your search. Why is your search date really important?
Because it can change any point after that.
Because maybe your title is a snapshot in time, and that's why they got a date and a time on them. When are you going to be using that? Like, is there? Oh, well, say if you're doing an INET report or something like that, would you actually specify what the search date was on your report? Yeah.
Yep.
Always a good idea. Then the addition and the date. What's that all about?
The last time it changed.
Yeah,
What's
is it
not
every
exact-
single change, or is it
It's-
what sort of change?
It's not, I can't remember what it's not.
Change to the first or second schedule.
Yeah.
Got notations though. Would that trigger a change number?
No.
Yeah.
Because notations can be unregistered plans or dealings or whatever. That won't change an addition. What about a caveat? Where does that appear?
Caveat would be in notations.
Yeah. Cool. So, yeah, like you just said, anytime there's a dealing that affects the first or second schedule, the addition's going to change. Was primarily there back when there was paper titles, because there actually was a physical. There was 2 copies, one in the RG, like with the RG, and one with the registered proprietor, or usually the mortgagee. And they actually would get reissued a new paper title every time the edition changed. So the next bit, the land, kind of is what it says it is. It's describing what land is actually included in the certificate of title. So in this case, you got lot 402 in deposited plan at West Pennant Hills, local government of Hills Shire, parish, county. Are these dates? Sorry, are these localities, local government areas, etc., always correct?
No,
Why's that?
because the CRE, they won't change unless there's something that happens on the title otherwise. So you need to use the CRE on the title.
Yeah, so if you've got an older title, let's say it's been hanging around since the 90s or something like that, and there's been a local government amalgamation or something like that, the local government area is most likely going to be incorrect on there. Now, bonus points here. Can anybody tell me where that can end up coming into play when you're getting a bit further down the line after you've prepared your plan?
When filling out the administration sheet.
Well, yeah.
Yeah.
But I'm thinking it's
Sorry.
further on than that. It's all right. If there's anybody here who used LRS Connect.
Yeah.
Yeah. So when you go
Where is
create a workspace, in LRS Connect, it'll ask you for the title particulars, and it'll start doing in the form builder. It pulls the locality, LGA, parish, and county off the title. So if it's an older title, there's a chance that could be incorrect, and you may have to fix it up in LRS Connect. But that's probably getting a bit further than what you need for the exams. It's just something to know. Easy fixed, but it's just a little glitch they put in the system. It shouldn't be pulling it from the title. Okay, we might just I might just find another one that's a little bit different in that respect, to do with the description of the land.
All right. Do you want? I'll stop sharing so you can.
Yeah. Second. Bear with me a second. I'll find one. There we go.
I've got one on the screen there, mate.
Yeah, that's what I was looking for. Okay, so tell me what's going on with the land on this one.
$750,000 number, so it's a Crown plan.
Mm-hmm. See there where it says the title
Yes.
diagram, it gives you the Crown Plan number. So that's something that's you'll come across.
So you don't always have to go to the parish map to get the Crown Plan number or the portion plan or the town plan. You can get it from the CT.
Yeah. You got an auto console somewhere there, Monty?
I'll go try and find one.
Just look at it. Oh, hold up, I can find one. I know of one done recently.
Weren't we saying caveats would be on the notations there, Guy?
Yeah,
Be on the
I was sort of,
second schedule there.
I couldn't remember. But yeah, it looks like they're in a second schedule.
What is an auto console?
It's where somebody owns the title of multiple lots, and it's easier just to consolidate them into one title, and then show up the top there that this title refers to a number of lots.
So what's actually consolidated? What's actually consolidated? Yep, the titles. So
Titles,
so all the titles are basically put into one folio.
So why might they do that?
You can save money on rates.
Are you going to save money on the land rates, or is it going to be on something else?
Value.
If you own a property and you get a rates notice through for residential land, what's going to be on that rates notice? You'll have your land rates and you'll have some other stuff as well.
But I've never had a rates notice, so
So on there there'll be garbage, like waste collection fees for each lot. There may be other stuff too, but that's generally what you're going to save on, is that sort of stuff, because they treat it as one property rather than two. I think there's actually ways you can get around that without having to do an auto console if you contact council, but that's why a lot of people do it. It also makes the land a bit easier to deal with if there's a large holding, for example, in a rural situation. But yeah, as Moddy's pointing out there, rather than it showing the title diagram at the top, it'll show you a schedule of parcels, which shows you what the title actually consists of and the Crown Plan numbers.
Can I ask? I've got one. I don't know if it's similar to an auto console, but my title is a subfolio, and there's obviously two titles over the land, but they're the exact same besides the subfolio number and the edition number. Do you want me to chuck that up quickly?
Yeah.
Yeah.
Can you guys see that?
Yep.
Cool. So that's my one of the two titles for the subfolio. See, it says here. So when I went to order my CT, we use OzSearch. It came up with like an error and then said I had to order the subfolio instead. So I went and I did that. This is one of them, and then this is the other. It's the exact same first schedule, second schedule, land and notations, but a different edition number and a different folio extension. I don't know anything about subfolios. So what does that mean? Is it similar to like an auto console? Why was that created?
It's pretty much the opposite of a auto console.
It's like to do with shared ownership of a Torrens lot. Kind of.
But it's the same owners. That's why I'm a little bit confused.
Yeah,
Sorry,
Christy, there's an unregistered dealing on that, which is a
that's just our PPN. That's just
your PPN.
Yeah.
I haven't done that in because of the draft. I assume at Torrens 2-lot
Yeah,
subdivision.
we're going
have
to do
they?
a subdivision. We are, but I'm not, for my exam, I'm doing redef because they're not ready for the subdivision. But that's just our PPN for the subdivision.
They used to do it with like where there was timeshares and stuff like that. That's one of the situations where they did it. I've just done a bit of Googling while we've been looking at this, and sort of things of that nature. Might not necessarily be a timeshare, but where there's shares in a particular
Have a look at the land description. It says half share in lot such and such.
Yeah.
So there are actually 2 physical titles to the land where these particular owners own half of it and the others own half of it. So in that they can each have borrowing power on these particular titles. However,
So-
if you're dealing with the land, you've got to deal with all the owners, so you need to deal with both titles.
And when I do my redefinition plan now, which is not a real plan, but for exam purposes, that would then consolidate into one title, considering it's the same owners? Or no?
Personally, I don't think so. I think they'll still create
Okay.
sub-folios based on the new lot and
I think
deed.
I agree. I think they will too, unless there's a transfer.
Yes, there has to be a transfer.
Okay. Yeah, that makes sense.
Because just remember the reason that you don't have to get all the verification of identity requirements and that sort of stuff for lodging a DP as opposed to like a dealing where they've got to actually go through that whole process is because a subdivision plan doesn't actually, or a deposited plan doesn't actually change the ownership of anything.
Yeah.
And even if you're doing, say, a boundary adjustment or something like that, where there's a piece of land that's going from one ownership to the other, the plan doesn't actually do anything to change the ownership of that little bit that's going from, say, lot 1 to lot 2. There has to be a transfer lodged. So, yeah, whenever you do a plan, the plan is just redefining the boundaries or defining the boundaries for whatever title is going to get created, but there's no change of ownership by a plan.
Yeah.
Or the
Yeah,
ownership
okay.
structure.
Yeah, cool.
So
But what is the purpose of these sub-folios? Because if you make any change to land anywhere, you'd have to get, like, it's not like you're only getting one of the sub-folios affected, are you? You're getting all of them. So
Yeah,
how
that's
is
right.
that different to just having the first, like, this one has a first schedule with shares in it? What's the purpose of having another title? Like, wouldn't that just incur more rates? When is it useful?
they're pretty uncommon. I think you'll find that they're probably a hangover from the stuff that I was talking about before, where there's multiple interests in a piece of land, and like based and yeah, I don't know. I think these days more often you'd be inclined to see them as tenants in common or whatnot. What do you think, Marty?
Yes and no, but I've been in a situation where we've had to create an easement over a piece of land in out Muswellbrook Way, and it was a farm, and we had two sub-folios on this particular farm. So it could be 2 titles that were created when farms may have been joined or something like that. I don't know actually how it came about, but again, it created separate titles based and I said they can have different borrowing power based on these half shares. So I don't know exactly how they come about. I'd have to do my own research on that one. But Christy, I'd probably do some research because they may actually ask the question.
I very much anticipate they will.
Well, I probably be prudent and just not intimately know what it's all about, but just
Yeah.
have an idea of what it is, because I reckon it could come up.
Yeah.
You know how I was joking the other day, Christy, that about what was going to be your thing that was going to get you the prize this time? This will be it.
You got it.
My research into subfolios.
Then you can
Awesome.
teach
Thank you
us.
very much. Thanks, guys.
Okay, I'm just having a look. There's nothing really coming up in Horman either.
It won't be a common question to everybody. It just might reflect on Christie's job. So I don't think everybody needs to know intimately what a subfolio is, but
But if you find it interesting, go nuts.
yeah,
Yeah.
try and milk the time with it.
All right, cool. So I think we've probably covered the land bit. So if we want to bring a title up again, I'll bring one up. So we've got an auto console here. This is probably a pretty boring one to be honest. Hang on. Can you guys see that?
Yep.
Yeah, cool. But not this one. So these guys, the Davidsons, own this property, which as joint tenants. Can somebody tell me what that means?
But it's like as per the will, all the distributions, etc.
So, kind of. I think
Have another crack.
We've got rights of survivorship.
Yeah, it's part of it. Yeah, so they own it jointly. So there's no shares. They jointly own it. So it's not like it's divvied up. The two of them own it. So then we've got, as opposed to that, there's.
I've got one, mate.
Oh yeah, yeah, share it up. So what does yeah.
So, go, mate.
What does tenants in common mean? What's the go with that?
I'm skipping a line.
Shares.
Yeah, they've got shares and
Right of survivorship isn't included, and you can pass it on to people.
yeah,
You can sell it.
so okay, now where does this come to be? I guess important to think
All
about.
right, take it quick.
You working on your board stuff, are you?
Keep on going there, guy.
Yeah, where does it come? Like, where's some situations where you'd be wanting to consider whether it's tenants in common or not?
Maybe in a business relationship or something like that.
Yeah, well, I guess that's the common scenario where they occur more likely because it's a bit more of an arm's length type arrangement. But I'm thinking from a practical point of view in your practice, where might this crop up where it might make a difference to how you proceed with something?
Easements. Easements?
Think of the concept of survivability or survivorship.
What are you saying?
Okay, so I've got a scenario at the moment, and it's a huge pain in the ass. But I've got a scenario at the moment where I've done a delimitation survey that requires the consent of the neighbours. There's 3 of them on title as tenants in common. One of them's dead, recently dead. So the consent came back with 2 of them signing it, but not the 3rd. So now it's a whole shit fight. Because we're trying to get we need to get a copy of the probate and a death certificate for this person that's died, or otherwise the title needs to that share of theirs needs to go to somebody who's alive and then get them to sign it. So it's a bit of a niche one, but that's the sort of thing where you can be thinking about this when you need to have this sort of knowledge in the back of your head when you get that consent back with 2 signatures on and go, what do I do now? Yeah. Okay. So Marty's highlighting something else. What's that bit that he's looking at there?
Oh, man.
It's the dealing that, or the transfer dealing that changed the ownership to what's listed on that schedule.
Will it always be a dealing?
No, well, what is a dealing? I don't think I know what a dealing is exactly. It won't always be a transfer. It could be a, like, I don't know what the letter is,
No.
or if you get it in the will.
I think
Well,
that's
that'll still be a transfer.
Oh, will it? Okay.
But what else might it be? I think something that a surveyor might be more involved with.
Like a primary application?
No.
No.
What's a surveyor likely to prepare?
88B.
No. A solicitor does that.
Sorry.
Conversion action.
Come on, don't think too hard. It's much simpler than you think it is.
An acquisition?
What about a plan?
Yeah.
So,
Sketch.
no, a plan. Like, so
Plan.
say if
Plan.
you,
Yeah.
subdivision plan, like it might be lot in a newly registered plan. The last dealing that created that title will be the plan number.
Oh, really?
Yeah.
Okay.
So say if it's say a subdivision that's just just registered, edition 1 of that title, that dealing will be DP1, whatever it is. Yeah. Anyway.
But then how would stamp duty come about if you don't have a transfer when they're buying that new lot?
So edition 1, the developer will still own it. So there won't be any stamp duty because there's been no
Right,
sale.
okay, I see.
Yeah. Okay. So the little letter at the front of that number. Well, there you go. There's another one. Okay. So mind you, I was wrong. It won't have a number there if it's the subdivision, but if there's been an easement plan that's done it, there will be a DP number there. Like the last action was an easement registered by a plan. So my mistake there. Yeah. Alrighty.
There's also other prefixes. Anybody can guess what a CN vanilla is?
Change it.
Oh, CN, not sure.
Change name.
Yep.
Yeah, it's a change of name, so that could be the dealing of a change of name of that owner. So it's not always a transfer. It can be a number of things.
Yeah.
But in general, if you see a T in front of it, yeah, it's a transfer. It's that prefix letter that we need to use to find out, okay, what sort of dealing is it? Has anybody got one that may have something different in the first schedule?
On a lot of T's. Ooh, what's an AE?
It's got to do with the transfer through executor of someone's estate, something like that.
Look at you go.
So AE or AD?
AE.
Right, I got
Because I
AD.
did a delimitation plan where that was on the title and I had to look it up.
Oh, what about ND?
Notice of death.
Yeah. Good.
What's AD?
Um,
Okay, now I'm gonna look it up.
what's AY? You know what AY is? It's a possessory application. They're pretty rare.
Just throw up that shortlist up, mate. I think I've actually got it in the chats from last time.
I don't know where it is. If I see it and I don't know what it is, I Google dealing and then that code, and you usually get the dealing form come up and you can see what it is. That's what I do.
I actually made an Excel sheet with all the notations on it just to make it easier for myself.
Good on you. That's awesome.
I've got a name. Did you say
I think-
AQ? A CN and AQ.
Okay.
What's AQ? Yeah. All right. Let's not get hung up on that.
Yeah.
That's just trivia. Alrighty. Second schedule. What sort of things are you going to see in the second schedule?
Easements, restrictions, caveats.
Yeah. So interest in land, in the land.
Yeah.
So the first schedule's about who owns it. Second schedule's about who's got an interest in it. So, let's try to find an interesting one. This one. That's not super interesting, but it's kind of interesting. So here you can see there's reservations and conditions in the Crown grants, because remember that with Torrens title, you get granted, someone got granted a piece of land with some strings attached to it. And they mightn't have got certain things, hence the reservation. So might say that, I don't know, timber was reserved or something like that, or minerals. So basically, yeah, you own the land, but it's subject to whatever was in that grant. That's what that's saying. Limited title on this one, then a mortgage. That one with the easements on it. There we go. This one is different again because it's actually in a community title development. So it's in a community scheme, and you'll pick that up straight away when you see the plan number, but it also tells you that there's interest on in the management statement, and also on the folio for lot 1, which is the community property. See here that there's covenants. Can anyone tell me what a covenant is?
Must do.
Yeah. Or must not do.
It's negative, so it's a must not do.
Yeah.
That was restriction. Or
No.
does it have to say if it's a
Same thing.
positive covenant, that's a must do, and then covenants?
Well, a restriction on the use of land technically is a covenant. It's
Yeah.
just it's a covenant in the negative. You must not do something, whereas a positive covenant is you must do something. If you say covenant, it's just an older term usually. It's usually an older one. Then here you can see easements that were created. Also, with these in the second schedule, it always gives you the creating instrument, which in this case is DP 807535. And here you've got a right of way 20 metres wide, pertinent to the land above described. Anybody know what appurtenant means?
And bidding.
Yep. And what about if it says somewhere here? Not see any affecting the land there. Yeah, anyway, just on a quick scan, that one doesn't have any. But yeah, like You can see there's a few notations. There often is with these community title developments.
I just back to
Especially,
the interest on the community land on the second item.
Yeah.
What's that to do with? Is that just a standard notation that is on community title, or?
it'll be on every community title. And that's tying back to the community property.
What one?
So similarly, on a strata plan, title for a strata lot, there'll be a link back to interest recorded on the register folio and then the common property strata plan, blah blah blah.
Cool.
Yeah.
It's kind of directing your attention to a different title.
That's right. And that's what second schedule's about. It's directing your attention to all these different things. Title's just whilst it provides indefeasible ownership, it also directs your attention to any registered interest in the land as well. So you might also see other things in there, even road widenings and stuff like that too. I don't know if you got one handy moddy that's like that, but
that doesn't have a road excluding road. I don't have one in front of me. No, sorry.
probably somewhere. Just gonna find another interesting one. I'll bring it up. There you go. So this one here, you can see that there's been some easements on the land, and there's been some subdivisions and then further subdivisions, boundary adjustments on this blocks of land. So some of these original easements only affect parts, and then or affect next door. So and they've been released insofar as they benefit this bit, but then it still exists benefiting something else. It's a bit, when you start looking at this stuff, it sort of starts to get a little bit more complex sometimes.
I've done that down, right?
Sorry?
Can you try and dumb this example down? So it's been the lot's been subdivided, and the restriction or the right of way is still only for part of the land. Is that correct?
Yeah. So this it's messy, this title. So basically, what's happened is there was an older block that had an easement that I'm just going off memory here. There was an older block that was affected by a right of way over it, benefiting some other lots down the line in another plan. And then I think there was a boundary adjustment done on that lot, and then the easement was released insofar as it benefited one of those lots further down that had the benefit of that right of way. So it's only been partially released. There's still another lot that's got the benefit of it. When you start doing, does that make sense?
Yeah.
Yeah. I can show you another
It
one
does.
that's an absolute shocker that's got 54 notations on it because of that sort of stuff. Anyway, do you see this sort of thing? And this job, when I was doing I did a boundary adjustment on it. And it was a bit of a headache, that one, trying to figure it all out. Just what was there still and what wasn't. That's an interesting one. So this one here, the block's owned by the local Aboriginal Land Council. Yeah, basically it needed if there was any dealing to be done on it, there was restrictions to do with this Section 42 of the Aboriginal Land Rights Act, and it was going to affect the dealing of it. And then you can say that that's been released by court orders. And then you can see in notations it says referral dealings and plans to Indigenous Title and Legal Division. So if you get something like this come up, it's not going to be going through the usual process of getting registered.
I've got something there, mate.
Yeah, go for it.
Have we gone through what is an actual caveat?
No, not yet.
Okay. You could get asked, what is a caveat? Anybody know what a caveat is? Because these are some general questions that they could ask you about. You know, what is a caveat? What is a memorandum? Well, I'll get an answer from you from that one. What's a memorandum? What is a writ? WRIT, and there was another one.
Caveat a proprietary interest in land.
Does
So
in terms of Latin, what does caveat mean in Latin?
Warning.
It's a warning. So basically, the caveator, being in this case, Ingwerson and Lansdowne Securities Limited, they've lodged a caveat to say that, okay, if any dealings happen on this particular land, we want to be warned, and so therefore that prevents them from doing any dealings without the caveator's consent. So there's a couple of different types of caveats. There's one that's a temporary one, and there's one that's more long-term, and it's all based on, particularly with lending of money. It's not a mortgage, but there may be some securities in place that the land itself may be related, and so therefore they want to stop any dealings of the land till the caveator has been satisfied. The Ausgrid and some of the electrical people, they put caveats on because they have some of their infrastructure in place, and they don't want, they want to protect that infrastructure. So what they do, they lodge a caveat when that infrastructure gets built. They lodge a caveat to say, okay, we're not allowing any dealing happening until you protect our infrastructure with an easement or something like that. So a caveat is a warning to the caveator that they're dealing with the land, someone's dealing with the land, and they need their consent. What's well, staying with caveats, sorry. What's this asterisk mean?
nothing anymore.
Okay,
Those
what
are
did it mean?
It's just the notation down the bottom that says, oh, they're not on the current edition of the certificate of title. But now that we don't have paper titles,
Right, yeah.
can't not get the current edition.
So historically, it was put on the title, but you didn't need to lodge the CT with it. So historically, that's what happened. So if you've got a CT with with a little star in front of it, asterisk in front, know what it means. What about a memorandum? What's a memorandum?
Legal document
Yes.
stating terms,
Sort of, yes.
potentially an easement.
Well, that can formulate a monument, a memorandum.
Like the essential energy terms for their
Yeah.
easements.
Yeah.
Who else might use something like that?
Could
There's
it
a
be
clue. There's a
like
clue
how
in
they
number
want
3.
the land developed? Not like a strata development plan, but like say they need so much housing commission on the area or something.
Yeah, so that might be like a voluntary planning agreement or something.
Hmm.
So
Which
you
is
said
different.
You said clue in Schedule 3. Would that be the bank?
No,
Bring it
yeah. Banks use it. Why might a bank use it?
In regards to the mortgage holder, so the terms of the mortgage, etc.
Yeah, so that's
Yeah.
a lot of mortgages will refer to a memorandum for the actual terms of it.
Okay, so based on that, what is a memorandum? In much broader terms.
Is it like a bylaw for a Torrens law?
Well, that is one particular. That's one particular memorandum. But basically, what it is, it's a public note. That's what a memorandum is. It's a public notary that's been registered. And so many different parties can refer to that public note, whether it being an easement, terms of easement, or being a strata notations for services and maintenance, or whatever. It's a memorandum. It's a public note that's registered, and instead of having to, particularly with Ausgrid, instead of having to write out their terms 50 million times on all your easements, you just make reference to the memorandum. So it's just a public note, so that and registered, and so it can be referred to for terms or whatever. Okay, so what's a writ? I've heard of these particular questions being asked, so probably need to have a basic understanding of what they are. Yeah, okay, well done, George. Look that one up well.
Is it
Basically,
WRIT?
WRIT, yeah. Yeah, so basically it's a court order that's registered on the title. It gets put on the title. I don't know if you've got any samples there, Guy, but it means that there's been a court order, and so therefore to and do with dealings of the land, you might have to
I
work out
suppose
whether.
that one by the Land Council probably had one on.
No, I didn't see one.
Here you go. Find it again.
But have an understanding of some of these dealings or whatever, how they operate.
So here it's talking about see court orders.
Yeah, well, it may be something. I can't categorically say, but I've actually seen a dealing number and writ, and the word writ, and says that it's court order, and it might be an order of the court to make payment for something. I don't know. But
Anyone
it
knows
does.
charges?
Say that again?
Charge. Usually when somebody owes some money to somebody, they might lodge a charge against the title so that they can't deal with the land until that interest has been sorted out. So I've seen it before where Revenue New South Wales have lodged a charge on a title, and I've ordered it just out of curiosity once, and it was full of fines for all sorts of stuff.
On the LRS website, it's got a writ issued by a court does not create an interest in land. So does that mean that you wouldn't need to get like a letter of consent for them if you wanted to change something?
I dare say it would need to go to court to do a dealing. Yes, it's not an interest in land, correct. However, it could have something to do with the land, and the court orders whatever the court orders to satisfy what that dealing is. Then you may need consent from the court.
So it's probably like it'd be up to what's in the wording of that writ, you reckon?
Correct. Yeah.
Right. Okay.
So here's one that I noticed Moddy had one that was kind of similar as well. If you're around the Hunter, you'll see this a lot, and you may see it in Sydney as well with motorways and that sort of thing too, tunnels. Accepting the land below a depth from the surface of 15.24 metres by the Crown grant, blah, blah, blah. And that's basically saying that you only own the land from the stratum of the land only goes down to 15.24 metres below the ground. Anything below that you don't own.
Is it defined in a stratum survey or?
No, this was just in the Crown grants because they probably had minerals below it.
Oh, Crown grant, yeah, gotcha.
But the motorway stuff, it might be to an RL or a ton, like tunnel stuff. Usually will be. And there'll be a stratum plan underneath it for the lot underneath it. Not only for that, like you can have stratum lots in buildings as well. So that was that one. This one's interesting. This one's owned by this Crown land. Talks about how it's a reserve and needs consent from the minister for dealings. It's limited title. The fact that the plan under it is not a current plan. And then there's also an easement for pipeline created by Gazette and showing an easement plan as well. So that's interesting. This one here. This one's got a lease on it, which shows you when it expires and that there's an option for renewal. Then this one here, the other thing that's interesting about this, firstly, it's an auto console, but it says here, note, cross easements, section 181B may apply. They don't seem very sure, do they? My opinion is that they do not on this site just because of the age of it, but we'll go into that later.
Well, can I give an indication of that now, mate? I've got one right in front of me.
Yep.
Okay, so you guys doing your city jobs, what's that all about?
That's an easement or a cross easement created prior to August 1996.
Under
Real Conveyancing Act.
so probably jumping ahead here on your guy, but what does that mean? Yes, there's cross easements for support. How did it come about? Are you guys doing party walls? What's this all about? How did it come about? What was section 181B all about?
Dealing?
Yeah, it's a deal, of course. Yeah. Okay. just keep that in mind for when you do party walls. That's a definite thing to keep an eye on, and that's what Guy was just showing on his title, is that the section 181B may apply. Definitely doesn't say it does. It only says it may be, so you need to do further investigations. But in this particular case, it does apply, and that's
So
the proof of it.
Can you still create cross easements via section 188B?
No. You can do it under 88BB.
Yeah.
But 181B is no longer in force.
But that's just the pre-August 1996 plans.
Yep. So in my situation, the reasoning behind my opinion that they do not apply for mine, the building was like the original plan. There was a plan of survey done in 19, which is weird because it's limited title, but anyway, there was a plan of survey done for a subdivision back in 1926 of these buildings that were in a row. The land was disposed of quite quickly after that, and by the looks of things, there's never been a deal. Well, to start with, the land. So the party wall notation was done in 1926, so it was pre-1935. So 181B wasn't even enforced then because it didn't come in until 1935. And I'm not aware of any dealing that's been lodged to create any cross easements since going back, and none of the deeds between now and then talk about it either. I've been through them. So, yeah.
Anyway, we'll probably cover that more in more detail when we actually do party walls. But just keep that reference of a CT in your mind.
Okay, so this one here, in the notations, it says this folio may be associated with the Crown tenure, which is subject to payment of annual rent. Further details, contact Crown Lands. Any idea what that might be about?
A lease.
Of what?
Leasehold.
No.
Lease over Greenhound land.
Yeah, so they might have a lease over a jetty or something like that. Which in this case, this is a waterfront property on Lake Macquarie. And they've got a jetty that they lease off the Crown and pay annual rent to the Crown for. So jetties, boat sheds. The other thing where this might come up too is if there's a rural property that has a road enclosure permit on a like on a Crown road that goes through the property to graze it, you may see this come up there as well. This one's a fun one. This one's got a nice little nasty qualified title on it. So basically, well, do we want to cover limited and qualified title tonight, Monty?
Yeah. Let's throw that out.
Yeah. Let's just quickly talk about unregistered dealings. What sort of things would you see in unregistered dealings? We'll come back to this one. In the notations on unregistered dealings down the bottom.
PPNs.
Sorry?
PPNs.
Yep. What else? There's an example on the screen there.
Proposed easements, etc.
Yep. What about proposed road widenings? Another thing you'll see, you see plans that have been lodged, see dealings that have been lodged. Yeah. plenty of things in there. Just bear in mind as well that you may see in the notations I talked about proposed road widenings. That means it hasn't gone through yet. But you may also see in the second schedule that there's been land acquired for whatever reason. It might be road widening or whatever. And if it's been acquired by Government Gazette, the title reference won't change on the land that's left over. And the title diagram will still be the same as well. And it may not even show that there's been land acquired from it. Probably won't. So this is why you need to be reading your titles really carefully, because there can be blocks of land where there's significantly less land than what you think there is just by looking at the title diagram. That makes sense?
So where would you check that, Guy? Unless if it was an older, pre-September 2002, it'd be on the charting map. But if it's
on the title,
the title,
it'll show up in the second schedule.
Sure.
Hence, if you're just going out to pick a lot, what should you be getting? Client walks in the door. I need you to peg my boundaries. What's the first thing you're going to be ordering?
Give the title.
Title.
You're going to every job. You're going to get the CT because not everything is shown on the plan, as what Guy's just saying.
And the other thing too, like if you've got a job that's going for a little while, it's a good idea to order the title again. Never know what's happened. I've had it where I've gone to lodge a plan and I didn't order a title again, and someone lodged a caveat, so my plan got requisitions because of it. Won't be doing that again. But that's pretty minor in the scheme of things.
You can check the edition number on New South Wales LRS.
Yeah, you can, but they won't tell you if there's been a caveat ordered.
I thought caveats are on second schedule.
Yeah, but they won't create a new edition. They're an exception. Anything that has an asterisk on it, like any of those sorts of things. Like the other thing that can end up on the second schedule that won't necessarily create a new edition is if there's been, say, someone grants you an easement and you've got an easement that's pertinent to you, doesn't affect your title, but it benefits your title, that may not necessarily create a new edition either. There's a few things like that. They probably should stop that now that if they haven't, but now that there's no paper titles, but certainly has been an issue. All right. So let's talk about qualified title. Who can tell me what qualified title is?
Version from old system, title converted from old system that doesn't guarantee interests.
So why do they do it?
Just to get it onto Torrens.
Did they get it onto Torrens, or is it some sort of like pseudo Torrens?
They're more like a preliminary torrent, so they've
Kind
been
of.
qualified.
So why did they do it?
Was it when there was questions over the chain of title?
Bigger picture stuff here. Like
They're
what was
trying to do
what
it
was the
quick.
reason why they started this conversion project?
To try to get as much old system converted over to torrents as quick as possible.
Yeah. So what about the practicalities of dealing with it, with Torrens title versus old system?
Indexing and searching and dealings and conveyance.
Can anybody tell me what the term good root of title means?
At least 30 years.
Yeah, so when they were doing old system conveyances, which is what a deed is technically called, it's called conveyance. That's why conveyances, as in the people, are called conveyances, because they used to prepare these things to convey land. These conveyances used to have to, for old system land, go back and show a good root of title. So they're going back 30 years at least to show that there's a good root of title. And the other thing too with it is that people can come along and have a competing claim. So it's just a really messy way of transferring land to start with. And then also it's sort of like I said, there can be competing claims rather than having someone on a register. So there was always the way of converting, or after 1863, there was always the way of converting land from Torrens title to, old system land to Torrens title by means of a primary application. But in the later half of the 20th century, when they started doing this, it was just going to be too big a job to try and do that for all the old system land in the state. So they started creating these qualified folios where, and often they were limited folios as well, usually, where they would basically go, right, well, the Torrens system requires a title and a plan. We can't guarantee the ownership of it, so we're going to create this qualified folio. And the whole point of that was to make it so that there was a consistent system of dealing with land, buying and selling it, rather than having to go through this whole other process every time, which was just messy and time consuming. So with that in mind, of thinking about that process, can anybody tell me what the three different types of qualified title are?
$28J, $28J1, $28J1A, is it?
So 28J and 28J1 are more or less the same thing. But what about the other two? There's 28J1. What else?
Uh, 28J1A and 28J1B.
Okay, so let's start with 28J1. What was the story with that?
Before you go
What?
too much further, can I just show something up there, mate?
Yeah, sure.
It's extending to what Guy was saying before about a good root of title. Here we have an old deed where the prudent solicitor had to do a root of title, and he's actually shown it in a schedule at the bottom of the deed.
Mm.
So he's actually given a root of title on the actual deed. So some brilliant deeds, you'll get a root of title that may even go, well, maybe not as far as the land grant, but it will give you a series of, or could give you a series of deeds for that root of title. So just keep that in mind. Have a good look at those deeds, and you may have that situation.
Otherwise, you might end up like I did recently, having to go back through the bloody indexes. That's good fun to try and see what was going on with a block of land that I was doing a job on. So
Guy
But
and
it-
Monty, if you've got a job that's limited to qualified title, right?
Yeah.
Now, and they require, let's say, a survey, a redefinition, right? So it's 12 years for J1 1A. Is that correct? And
yeah, we're just going to go through that. So
Automatic.
not always.
No, okay. And then there's if it's the other one, if it's survivorship, it's 6 years or survey. But with this good root of title business, why do we have to prove that? And is that just done through historical title search?
We don't have to prove it.
Don't have to.
No, you just need to understand it.
Okay.
So 28J1, that's talking about when the land was what they did was they look at the last transfer and go, right, well, was this land a transfer for value or was it not a transfer for value? So say if it's been sold for like $1 or something like that to somebody through some sort of transaction that may not have been at arm's length, they gave it less, I guess, status. So as opposed to if somebody had paid market value for the land, the whole point there is that there's the assumption that if somebody's gone through and bought it for market value, they would have done their due diligence on it. So 28J1 was completed where there had been a transfer for value. Is that right, Monty? I think so, isn't it?
Sorry, mate, I just missed that bit.
So 28J1, that was where there'd been a transfer for value, was it not?
Yes.
So the idea being that somebody had gone through the process of making sure that there was a good route of title. And it means that with 28J1, you can either get rid of it after the limitation period, which is 12 years, and there'll be a caution entered on there and the date that it's entered. So if we go back to that qualified folio that I had, so this one here says that there's caution pursuant to section 28J1 and 28J1B. Now, the date at which that caution starts, let's look at this one rather narrowly for now, because it's got 28J1B, which we'll talk about in a minute. It's a different kettle of fish. Imagine for a minute that it just said 28J1 and it was entered in 2022. That in that scenario, you would have to wait until 2034, which would be 12 years after that, to lodge a cancellation of caution to get rid of it. Or there would be, if there'd been a second transfer for value and 6 years, then you could apply to have it lifted after that. So imagine there'd been a second transfer for value in 2023. The earliest that you could have that lifted with a cancellation of caution form would be 2029. That makes sense?
Yeah. And is that all just solicitors stuff?
Yes, solicitors do these. But you need to be able to, if you've got a client that comes in with one of these things, you need to know what's going on with it and how to deal with it, because you're going to look silly if you don't. Okay, so the way to figure out if have you got a historical search you can bring up, Monty?
Oh, good on you. Bear with me. But what I'm showing there is one of those forms, cancellation of forms. And in reading this, it's saying it's been 6 years since the last transfer for value. So so upon that end of the 6-year period, they've lodged one of these dealings to have that caution removed.
Is that the same as limited title, where you've got to put in a government gazette for 5 weeks and local council paper or whatever it is, local paper?
You don't need to do that for limited title.
You don't? Maybe I must be thinking qualified then.
No. You are thinking of something, but we'll cover that in a minute there, Jared.
I've got one here, Monty, a historical.
Okay.
So just talking about these transfers for value, this is where historical title search which you can order through your information broker. It can come in very handy. So this one, you can see there there's been a conversion action done in 1989. It's probably, and then it goes on, but you can see that there's been a transfer in 2019, and there's a discharge of mortgage there as well. So you'd assume that there's a fair chance that there has been a transfer for value there. So you may need to order, you'll need to order the dealings to find out what happened. And then prior to that was 2004. So this is where you need to go back through the dealings potentially to see whether there's been market value or value paid for the land in determining whether this can be lifted or not.
And so you arm yourself with that information, Guy, and then you advise your client that this can happen.
Yeah. So, for example, this client of mine with this lot, he's building a multi-dwelling housing development on this site. He was talking about doing strata subdivision on it. Now, can you do a strata subdivision with qualified title on it?
No. It has to be full tolerance.
No. So when he's coming to you and going, look, I need some advice from you, you consultant, what do I need to do to get this strata subdivision to happen? You're going to need to know this information so that you can advise your client on what the steps in the process are going to be. So now, if we go back to 28J1, we've spoken about that. So it's either 12 years or 6 years with a second transfer for value. 28J1A is where there was no transfer for value. So it may have been transferred between family members or something like that. And it might have been for $1, for example, or for love and affection. I've seen on deeds before as well. On transfers before. Basically, the upshot of it is that they are unsure whether there's been a transfer for value. So, how do you reckon you get rid of that? Anyone?
Transfer for value?
Yeah, so there needs to be a transfer for value to start the process. What about if there's a second transfer for value?
Years.
Sorry?
Wait 6 years after the second transfer.
Yep. So yeah, that's what needs to happen there.
Essentially
What
same
about-
as 28J1.
Sorry?
Same as 28J1.
Similar, yeah. So what about 28J1B?
Transfer by adverse possession.
Yep. So something funny's going on with this. So what do you need to do to get rid of the caution on that?
Is it a primary application?
Yeah. Yeah. So there'll need to be a primary application done. And for this example, that's what's going to need to happen here. The client's got that underway. Not that he's going to proceed with his strata subdivision because he's going to sell the whole thing in one go, but at the same time too, he's better selling it with a clean title. So that's what he's doing.
So
but
this primary application, that's if you've got to do a primary application, that's saying that it's not torrent. Is that correct?
well, no, it's not torrents. That's what qualified title is not torrents.
Yeah.
It's land that's been brought halfway into the torrent system.
Yeah, sure.
But there's certain deficiencies in the title compared to a torrents title. So it doesn't have the full benefit of indefeasibility if it's got a qualified title.
So you need to do a plan of survey then, is that correct?
Well, there's already been one done. So in this case,
Yeah, Jared, just think that all limited and all qualifications, those two, they have stemmed from the old system, and they still act and they're just put within the torrent system.
Yeah.
However, they
Gotcha.
still act and smell like old system land.
Yeah. Gotcha.
yeah, they're like a visitor at a club. They're not a member. They're only allowed there for a little bit and they're only allowed to do certain things.
So that primary application to remove the 28 J1B, is that just a form, or is that what's the requirements for that?
So primary application has to be there has to be a full root of title, like an official search done. So a full search done, statement of title particulars. There has to be it has to be advertised in paper. So it has to be advertised in a local paper and also a paper that's in circulation across the state. So, for example, in this case, it might be the Maitland Mercury and the Sydney Morning Herald, for example. And basically, it takes allow 12 months at least for these.
Yeah.
And the lawyer's going to be doing a fair bit of work. It'll also look at who's paid rates on it, all sorts of stuff. So,
do you ever apart from do you factor in your costs into your survey or your fee proposal for searching this after the fact that you found that it's a 28 J1B?
what do you mean?
Like you said, you said the historical title search has to occur.
Yep.
For the primary application.
So, like an official search, that's
official search.
You're talking more about what the solicitor is going to do.
Sure.
So I've got a good solicitor that I refer my clients to if something like this comes along, and then if they need some help, sure, hourly rates.
Yeah.
But yeah, that's how I deal with it. Yes, so that's qualified title in a nutshell. I doubt you're going to get asked much more than that in the exam, or even that much, to be honest. You will get asked about it and knowing the difference between them. But yeah, any questions on that?
I can do a quick share there, mate.
Yep.
I just want to quickly.
Sorry, guys. I was just going to ask, do they usually ask mainly these questions about qualified limited in urban or rural, or basically both?
Could be either, but probably more likely urban.
Yeah, what I've shown up is another historical title where in this particular case, the LPI they've gone and prepared a departmental plan on a block of land in Newcastle just to get it from old system into the new system. And in this particular case, they did a DP. That's a departmental plan, and they've done their conversion in 2005. And with regards to that, the departmental dealing then creates the actual CT. 12 months later, or 8 months later, the owner actually passes away, and there's a transmission to the trustees, creating second edition. So in that particular case, the title would have a J1A scenario because it wasn't created for value. And later on that year, the trustee, they've created a transfer and mortgage to sell it off to somebody. The clock starts ticking at that particular epoch. Then 2 years later, a discharge has been done and it's sold off again. So probably need these historical titles to find out when the clock started ticking.
So that one there,
you've got your second transfer. Sorry.
That one there, the second transfer for value happened in February 2018. So they could have had the caution lifted in February last year.
Well, you needed 6 years after that one. So yes.
Yeah,
Yeah.
cool. Okay, so it's more of an advice stage that we're kind of providing, and whether you can, as you said, Guy, go ahead with strata subdivisions or whatever.
Yeah. And also helping your client out by, your client's not going to know what it is, so they might ask you to provide instructions to the solicitor.
Can a plan of survey also cancel the qualification?
No,
No.
It's literally just time.
because to do with ownership. Remember I was saying before, a plan of
Yeah.
survey can't change ownership.
Well, that's a good question there, Jara. What if time hasn't elapsed? What if we haven't got that 6 years and the client is ready to strata it? How can we get rid of the qualification?
Wouldn't be a delimitation or primary application.
There we go.
First title creation.
Well, not
Well, no,
first
there's
title
already a
creation,
title.
no.
So
But
yeah,
be a
primary
primary.
application.
Yeah. See, that's the original methodology of getting rid of old system was the primary. They only introduced these other systems to try and speed up the process. But at the end of the day, if you haven't got that, that 12 years up, or you still got 28J1A, or you still got 28J1B, then you need to go down that primary application path.
Yep.
So it's all about timing and when you need to have this done and when you can't have this done. So yeah, so if your client walks in and it's got J1A, or he hasn't got 12 years up on his J1s, then yep, you tell him to get quick smart, get onto your solicitor and get rid of the portion. What is a primary? Someone give us a quick rendition of what a primary does, how it operates.
Application to get into primary school, isn't it?
So you just need to have a really quick review of what a primary is. Just have a working knowledge of how it operates. It's the solicitor that does it, but in general, there's a plan, there's a good route of title done, and more title searching that goes onto a form, gets lodged. That form, upon lodgement of that form, there's an advertisement and there's a advertisement period for 5 weeks, and after that, if there's been no, and the LRS will actually inform the adjoining owners, and gets advertised, gives the world an opportunity who may have a deed in their back pocket to say, hey, I've got an interest in the land. Here's my proof, and so therefore my interests would like to be recorded. And that's what this 12 years is all about, is to be able to provide the world an opportunity to be able to stand up and stake their claim.
So just to clarify that again, so obviously we've got for 28J1, J1A, we've got remove after 12 years or second transfer value after 6 years. Can they also be removed via a primary application?
Yes. Yeah. The first and foremost process would be a primary application for all of those. However, with an ordinary qualification being J1, then there's that opportunity of circumventing
the three ways to do it.
Yeah. Well,
and 28J1B can only be done with primary application. Is that right?
Yeah.
Yes. And with 28J1, you might need primary application if a transfer of value hasn't happened. So it all depends on your historical titles, what's happened. Has money been exchanged for value? And has the clock started ticking? So basically that's what a primary does. Instead of waiting that 12-year period, the primary application gives the world an opportunity via your advertising in 2 papers. And then after that, if there's been no submission, then they'll go ahead and give full title to the applicant.
Yep. So anyone got any more questions on qualified title before we move on to limited title? No, good. Who can tell me what limited title is? What do you reckon, James?
Not sure.
Christy's got a camera off as well. What do you reckon, Christy? What's limited title?
Boundaries haven't been not verified by the state.
Yeah, and what do you mean not verified by the state?
Hasn't had a planner survey.
Yeah. Very good. Those of you that don't know, I have a little thing where I ask you questions if you haven't got your camera on. I've forgotten about it so far tonight, but we're on now, so that's all good.
So how have these limitations come about?
Similar to qualified, it's been converted across.
Yeah.
Okay. Yep. Someone's tried to lodge a deed and they said, okay, get stuffed. We're not going to draw up another deed. We're going to whack it into the system. So what's generally the case with deeds? Is you have a deed, is there anything attached to that particular deed? How do we know the boundaries?
Diagram.
No.
Meets and bounds. It describes the boundaries
Yeah.
through meets and
Yeah.
bounds.
With old system land, there's generally no plan attached. So so in that, the only way of being able to draw up what's on that particular title is by the meets and bounds description. And who draws that up? Yeah. Thanks, mate. So there's a bit of a sample of a meets and bounds.
Usually
Commencing
the
at a
title's
point.
office, or if you're game, you can do it yourself.
Well, we don't actually do it.
I know. I was just joking.
Yeah, no. That's why they call them departmental plans. If you've got a sample of that, one of them thrown up there, thanks.
I've got the one from this deed.
Oh, brilliant. So here we have, we've got the deed.
Check out how much search I've got on this job.
You're down $1,000 before you even get the jigger out.
No, I'm not. Client pays for it.
And when this deed is lodged, they say, okay, this is the last deed.
Oh, I want to look at the title. Silly. Sorry.
Yep. But if you have okay.
Okay.
So to get it in the torrent system, we need a plan because anything within the torrent system needs a title and a plan. Whereas with deeds, you just have that meets and bounds description describing the land. And if you take a quick note in the middle of this particular one, the plan the title is basically, okay, this has been drawn up from this particular deed. So you guys doing a city job and or even your rural jobs, and you've got a limited title, make sure you buy that deed and you draw it up yourself. Guy will explain that in a little bit.
Mm-hmm.
But in that, we have the plan title stemmed from the last deed. Okay, throw this deed out. Oh, well, beg your pardon, you don't throw the deed out. We'll put that deed within the deeds papers, and we'll now give it a lot and a DP number. Get it into the system, and take a note within that second block. It says the plan prepared solely to identify the land above the above deed. The boundaries have not been investigated by the Registrar General and is not a current plan. So
Really?
just take note that it's not a current plan. So this particular plan is not current in terms of the Local Government Act. It's purely a diagram represented by the deed, so that we can have a diagram attached to the title.
Just something else that's good to note in these things is in that top right panel, talks about the last plan and the reference map as well. So that can also be good information to go back to. Like we should always go back to them and have a look and see what they're about. In this case, the last plan and roll plan 673 are the same thing, but that roll plan 673 is the charting version of that DP, which was a litho. A roll plan, sorry, not a litho.
So you'd be going back to your blue book for that roll plan number.
Yeah.
I'm guessing.
Yep. So
But our role in the primary application guy, can you explain that further, please?
So it's generally going to be, firstly, like primary application is always going to have a planner survey with it. Now that one I showed you before, there was also already a recent planner survey, so that can get lodged with it. But say for this one, imagine this was qualified title as well, which it's not, it's just limited title. There would be a plan of survey, so delimitation or redefinition or whatever it may be. And then, so our role would be to prepare that, but then also provide, because generally speaking, the client is probably going to come to you first. Not always. Sometimes they go to the solicitor and then it'll come through the solicitor, but I reckon probably 8 or 9 times out of 10, they're going to come through you first. And then you need to be able to advise them on what the process is really. And then depending on the solicitor, a lot of solicitors are pretty foggy on the whole thing. You may end up finding that you're giving the solicitor some advice as well. Unofficially, of course, because you're not a lawyer. But yeah.
Okay, and essentially knowing those steps.
Yeah, knowing what needs to happen to get to get a clean title, clean trans title. So.
You also discussed the consents required on, let's say, box 12, more than 12 years.
Just hold on a minute. We'll get onto that in a minute. All right. So I guess with limited title, remember that old system title was titled by common law. And it was to an extent it was titled by occupation as well. So if there was under the Limitations Act of 1968, that sets a period of 12 years where a claim of adverse possession can be made. So if you've got a fence that is not on the boundary and the deed boundary is past the fence, then whoever's been occupying the other side of it, and I'm not just talking about a fence, I'm talking about any occupation. So if they've been occupying that continuously for 12 years or more to the exclusion of others, and it's open and not by force and without consent, then there's the potential for that other person to have to gain title by adverse possession of that piece of land that's over the fence. So this is where you need to start considering this with a when you're doing a survey where there's limited title involved. I'm not just talking about where it just involves a delimitation, for example, because it can come into play when you're doing something else. It might even be as simple as doing like a detail survey. So in this, if you have a block of land and then another block of land next door to it, they're dodgy looking blocks, but anyway, you get the picture. There we go. And then you end up, ignore that one down the bottom. Go on. And you end up having a fence that goes like this. Now, if this block here is Torrance title, and this block here is limited title, let's assume that fence is greater than 12 years old. Can anybody tell me what happens with that boundary, what you need to consider, and what the steps are involved to figure out what happens with that boundary?
It would create a sliver lot.
No, not necessarily. So what's the process? First up, forgetting about any fence for a minute, in defining the boundary of a limited title block.
Using the deed description.
Yeah, so you're going to define the boundaries by title or by deed, same as you would for any Torrens block. But usually with limited title blocks, there's not much in the way of survey, so they can be a little bit more challenging, but you're using the same principles to define that documentary title boundary. Well, basically, it's just exactly the same. Where it becomes different is when the occupations come into play. Now, obviously, you should be looking at occupations in your boundary fix anyway, but we're talking about once the title boundary is settled. Once you've got that definition settled, that's when you start looking at the relationship of the occupations of your land compared to the title boundaries. So in this instance, we're assuming that the boundaries are settled for the title boundaries. What could potentially happen here in this bit of land here that's between the limited and Torrens lot, between the fence and the boundary there? Talk me through what the go is there.
Do you need a primary application?
No, just come back a few steps.
Adverse
Imagine you're
possession.
doing a delimitation of that block on the left. What's going to happen? What do you need to consider with that, with where that fence is, based on what I've said?
How old the fence is.
Yeah, we're assuming that it's over 12 years.
Can I climb up to the fence?
You want to elaborate on that?
Yeah, because you haven't occupied that land for more than 12 years.
So
Technically, the neighbour has been occupying it.
Okay, so not quite. So what you need to do there is you need to figure out if that other person has an interest in it. So you need to go through and look at you need to look at the principles of adverse possession first of all. So we're talking about it a second ago. Has the limitation period expired of 12 years? In this instance, we're saying yes. Has it been open and without force? We'll say yes. Has it been without consent? So I've got a situation at the moment where the fence has been moved over onto a neighbour's and they reckon that there's written consent. So I haven't seen it yet, but it's just another spanner in the works. But anyway, so that's something you need to consider. Is the person that the adverse possession has occurred against, are they able to assert their rights of ownership? So, for example, if you've got somebody that's been in prison or serving overseas with the Defence Force or whatever, or if they're a minor, can you do adverse possession against them? No. Anyway, let's assume that that's all been ticked off. It has to have been exclusive use of that land. So to the use of that, occupation of that land to the exclusion of all others. So what about if you go, righto, well, you go to the neighbour and you ask them, righto, well, do you have any interest in this bit of land? Do you care about it? And they say no. What do you do then? You're on mute, George.
Get a stat deck from them.
No. Yeah, you adopt the deed and do what? To get your
Get
plan
them to
registered.
sign the plan.
Yeah, so you do up a version of the plan that has a statement on it saying we're the registered proprietors of blah, 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 consent to the boundary definition shown here on. Okay, and they sign that. You lodge that as a letter with your plan. Easy. Your plan gets registered to the deed boundary.
Do you consult the neighbour? So once you've done your definition, you've got it all calculated, and you go, okay, this is the situation. Do you go and consult the neighbour, or do you send a letter or get the client solicitor, or how do you?
What I do personally is I write a letter to the adjoining owner on my client's behalf for them to go and talk to their neighbour, explaining what's going on with it and requesting consent nicely. And then saying, I'll put a line in there saying if we haven't heard from you within 28 days, then we'll proceed. It's a little bit more complicated than that, but basically it's always going to be better coming from the client if possible, unless there's some sort of terrible relationship there. Because I don't know, I'm sure you've all experienced this, but people get a bit suspicious when surveyors are working in their street, let alone next door to them. Unfortunately, but yeah, so what about if they turn around and say, no, we'd quite like to have that bit of land?
Then you've got to, you can only go up to the fence line and then do a subdivision and create a sliver lot. That
No, it's not a
then,
subdivision. You're on the right track, but it's not a subdivision.
Consolidation of the sliver and the torrens.
No. So
Delimitation.
it's still a delimitation of your lot or whatever it happens to be. But you're going to create a sliver lot. So what's the process? Can anybody tell me what the process of creating that sliver lot is? I'm just finding an example to show you. I've done one a year or so ago.
Bring the lot for identification purposes.
Yeah. So what are you going to show you? Well, what do you do before that? Anyone got any ideas?
Do you fill out the pro forma you've got on the screen?
Yes. And your plan. So this is the version that was lodged. It's not the registered version, but the only thing that's missing is the stamp. So here you can see I've got lot 321 and lot 320. And you can see here lot 321 is this sliver here, which is 2.58 square meters. And you put this note on your plan saying lot 321 created for identification purposes only, not a current lot for the purposes of Section 7A of the Conveyancing Act 1919. Lot 321 in the common boundary between lots 320 is not drawn to scale, just because I haven't drawn it to scale because it's so small. But yeah, that's the note above there is the one you need to have on it. And what they do is the plan gets registered and they don't create a title for it. But what happens is LRS will then write to them, and then they have to engage a surveyor. If they want to claim it, they have to engage a surveyor to do a consolidation of their land and the sliver lot if they want to claim it. That makes sense?
So this is, you've done the same process as the bloke that was happy to give his neighbour his deed dimensions, but this guy, or number 292 in this instance, has said, lot 292 has said, I want that.
Yeah.
I do not consent. I do not consent.
Yeah. Yeah. So you can see here, I've got 50-year-old occupations along there. And that's what I've had to adopt as the boundary of my sliver lot. And then because you've got to deal with the whole of your title, then yeah. So what about in this scenario that we're looking at here? I can tell you now that the other block next door, lot 31, is also limited title, but you can see that there's encroachments along here that are all pretty old. What's the go here? What do you think happened here, and why with what's shown on my plan?
Would that be option one, where the neighbours are happy for you to do take the dimensions?
This is a different option again. This is land out. This is you're occupying outside your deed.
Yeah.
Not up, like not. The first example I showed you, you weren't occupying all of your deed. This one, you're occupying more than your deed. So what's the story there? Yeah, so you could. In this case, the client wasn't interested in doing that. So we just left the boundary where it was. In a lot of cases, LRS will want you to create easements over the encroachments. But in this case, I wrote back to them based on my client's instructions saying, look, it's going to get knocked down soon anyway, so there's no point. And they were happy to register the plan based on that. So that brings us back, I guess, to the next scenario.
Was LRS happy with you to keep those encroachments though, or would they want like?
They were. They did. They sent a requisition notice to me, which advised that they would like, and I'll show you the requisition notice if you're interested.
Just on that one as well, Guy, if you weren't occupying more than your deed, you're occupying less. If you get sign off by the adjoining neighbour, you don't have to create the sliver. If you're going to, on the two limited title.
Yeah, so if the neighbour next door says that's fine and signs a consent, that's fine.
Yeah.
So I think if a second, I've got.
That'd be unusual, wouldn't it, though?
What's that? Where they sign a consent?
Yeah.
That's probably more common than not.
Where they go, whatever, we don't care.
Most people don't want to deal with it. So here's a consent. Let it open. But this one was a bit different. This one of the owners, so there's two owners on title. One of the guys didn't have capacity. He had dementia or something like that. I contacted LRS to see what they wanted me to do there. And in that case, so you can see here, it's this bit here that they're talking about. She signed for both of them. And I got the letter from the LRS gave me telling me what they wanted. And I put that in, I lodged it with the plan. So, just let me find that requisition notice I was talking about.
Guy, I've got one up at the moment in Newcastle in the Hill where the limited title doesn't abut the Torrens lot. So there's a sort of a gap in the cadastre.
Right.
So would that be a primary application for that? But the limited's arguably occupying that lot or that.
Have you identified what the land is?
Not yet, no.
Well, that's going to be your first step. Figure out, because it's probably unlikely to be a gap. It's probably going to be a residue of an old title.
Yeah, right. Yeah.
So you need to identify what that is, because you need to form a common boundary with whatever's next door. But yes, I see what you're saying. If the fence, if you've been occupying that, and you can meet those thresholds for adverse possession, it'll be a primary application.
Right.
Unless it's a difference in measurement, and you do have a common boundary with the Torrens land, and then don't need to worry about that. But yeah, you just need to be dead certain about what that land is next door to you.
Yeah.
So sorry, I got sidetracked then.
Yeah, Ben, it might
While you're
be
looking for that. Sorry.
Yeah, sorry, Ben. It might be good to show that another night.
Yeah.
But it all comes down to the application of Hamer.
Of
Is
what,
there
sorry?
Hamer's list of priorities in terms of boundary definition? Is it a definite hiatus between the land? That's what you need to discern first. But Hamer will certainly need to reply. But it'd be good to show that another night, mate. That'll be brilliant.
Yeah, I'll dig it out and sort of collate it a bit better than what I've got. So yeah.
Yeah. So it'd be a good application. Yeah, cheers, mate. Sorry, guy.
You're right. Sorry, I found a requisition notice. As soon as I find another one. Hang on.
Guy, with that last one where the building was encroaching into the next limited title block, did you contact the neighbour via letter again?
No. There was no need. My client had no interest in doing anything with it.
Yeah.
Oh, here we go. There was the only thing that LRS said on it was this. Which bit?
That's rubbish.
As if I hadn't considered it. Anyway, I actually liked the examiner on this one. I think it was Steve Gerard. He was all right.
Yeah, but it doesn't. It doesn't exclude his client from claiming that via primary application on later on down the track. He's still in possession. He's still in possession of it, but he's not doing a primary application to claim it now. But down the track, he still can make a claim over that bit of land that he's in possession of. And that's where it all comes down to: possession.
Yeah. So I guess the last scenario that we need to show is the other scenario. So what about this bit here that's on the Torrens title block? You got limited title next door, you're doing delimitation, and then next door the fence is on the Torrens title block. What do you do there?
Indefeasible. Nothing.
Well, you don't do nothing. What do you do? Yes, you form a common boundary with the Torrens land. Good. say if you were going out and doing a detail survey, not necessarily a delimitation or an ident or something like that, what are you going to do with this? What are you going to show, and what are you going to say? Say for that first scenario that we showed with the fence on your side. What do you reckon,
You
Ben?
show age of occupation.
Yeah, but are you gonna, if you're doing a survey on that limited title block, are you gonna say anything about that bit of land between? Like, sure, you say the comment on the age of it, but is your client supposed to infer that there's a potential loss of land there because of your because of the age of it? What are you going to do?
Yeah, you would tell your client that next door has adverse possession rights to that.
So
section.
what you do is, like, what I tend to do is I'd shade that area and say that this part of the land that could possibly be subject to an adverse possession claim by next door. Also, obviously, recommend a plan of delimitation be completed as well. But it's particularly important to think about if your client's planning on building on the site or something like that, because the boundaries can change and your setbacks can get stuffed up or all sorts of stuff. It's just, I personally won't touch limited title unless without getting it a delimitation done on it. Because people just don't understand and they end up forging on and it ends in tears. But, yeah. Anyway, anything to add on that, Monty?
No, I think that's quite adequate. But yes, with all your idents, particularly if you're doing an ident on limited title land, you need to disclose that sort of scenario. However, I do recommend you do a nice, easy ident. But yeah, that's your professional. That's your professionalism is to advise your client on such matters.
What about if you're doing an ident or detail survey on the Torrens block? What would you say there? Would you let your client know?
Next door was limited.
Sorry?
And next door was limited.
Yeah, in this scenario, say you were doing your ident survey or whatever on that Torrens block.
We don't generally buy adjoining titles,
Why not?
so I don't know how. I don't know. We just
How do you
if it's
know
all
there's not
Torrens,
something going on?
well, if there's Torrens, we don't.
If you ask the Registrar General's surveyors, they'll tell you that you should be buying the titles for next door. In practice, I know no one does. But if you're doing a DP, certainly, even if it is Torrens, it's worth doing. But yeah.
Why is that, Brian?
How do you know that there's not something going on there, like that's going to affect you?
You're talking appurtenant, and there's some easement or something, some interest that wasn't on your title. Is that kind of?
Well, there can be errors on title. That's another reason. But certainly in old areas like this, you'd be thinking about it. And that's where you get a bit of experience. Will tell you to have a look too, because you might find, like you might say that your plan might be DP 800,000 something or other, and it's a survey, but next door might be a conversion act. You'll see it on CRE if there's a conversion action there. And you'll see there's limited title, for example, generally, or it might be on the charting map. You're gonna have a pretty good idea before you even buy a title, whether it's limited or not. But yeah, it's if you're doing something in an area like that, I'd certainly be buying next door's title. And you don't use the old argument of, oh, but it chews up the budget. Charge your clients for your search. Then you don't have to worry about it. Yeah. And we probably need to wrap up, like I say, but yeah, sure. Whoa. That's familiar drafting. Sorry? Oh, I have it now?
Yeah. Go, George.
Is this your item you're going to take to the board? Find an easy one. Okay. So what's this? Okay.
Yeah, this is your calc sheet, right here.
Yeah.
Just again, might come down to Hamer as well.
Have you fixed the
So-
lane? Have you fixed the lane? So is it meant to be straight or has it got all those kinks in it? Okay, so what's your question again? Hang on. Why would you create a hiatus?
Yeah.
So you've just laid PO by the deed.
Mhm.
What's the accuracy of that deed?
Again, I think we should be. Well, how about we leave this for another night there, George?
Yeah.
Because we need to establish Hamer, and I think you should be applying Hamer in this particular case.
Yeah.
Yes, we'll have a look at it another night, but for your homework, have a look at what Hamer's telling us. What should we do when it comes to redefining boundaries? What's Hamer's list of priorities? And I think in this particular case, I think we should make application of Hamer's list of evidence of boundaries.
All right. I think that'll have
Yep.
to do us for tonight. Thanks.
Yep.
Everyone.
No, that's your homework, George. you look, read up on Hamer's list of priorities, man.
Yep.
Righto, guys. I'll just stop recording, and that should be available in the chat. So if you need to go back and review, brilliant. It's only there for a limited time, so it'll be gone in maybe in a month's time.
Yep.
Righto, guys.
Thanks, Marty.
Well,
Thanks, Guy.
All
Catch
right.
us later.
Thank you.
See you Saturday, Guy.
Thank you. Have a
Yeah.
good night.